So let's talk about how to write for a contracts essay on the California bar exam. One of the most least liked areas to write for and take multiple choice for on the California bar and even in law school. So contracts has three main types of fact patterns. The first one is a heavy formation essay. So you're looking for facts that don't substantiate that you have an actual valid contract. So if you don't have language like the contract is in writing or valid written agreement, that means you're not in a formation essay, and it's more like the second scenario, which I'll go into in a moment. Then you are in a heavy formation essay. And in this type of essay, you have to first establish the applicable law, and then UCC versus common law, and then go into offer, acceptance, and consideration, and really do a very good job. You could have multiple communications. I recommend that you head note the communication pursuant to the issue that offer represents. So for instance, April 1st phone call invitation to deal, April 15th email offer, April 20th text counter offer with the specific rules pertaining to those types of issues. But eventually you will likely have an offer. Very rarely have I seen a contracts fact pattern, formation fact pattern without a full-blown offer, a manifestation of intent to be bound by the terms of an agreement that is communicated between the parties. So you likely will see that. And then you get into acceptance, and unequivocal acceptance is what is needed. And usually that's pretty clear to substantiate. Now you could have multiple communications within acceptance as well. So you can use those specific headings for labeling the actual communication as opposed to trying to hit all of acceptance like in one paragraph. And then go into consideration, make sure you substantiate the bargain for exchange, the promise for the bargain for exchange, and then go into potentially promissory estoppel, which is your backup to lack of consideration. Now, here you can also be on the lookout for quasi-contractual issues. So for instance, if formation did not occur, then in equity, you can ask the court to impose quasi-contract, which will back up formation. So if the parties acted like there was an agreement where in fact there was not a writing, you can ask the court in equity to still act like there was an agreement, and the judge will decide at that point. But for the bar purposes, that's where you discuss it after formation. I have seen some models go into it further down, like in remedies, but I just think strategically it makes a lot more sense to discuss it right after consideration if formation has failed. Now, again, your first scenario, the heavy formation essay, going into really substantiating the validity of the contract. Now, don't go into any terms yet because you have to go into the statute of frauds. It's a major issue in the formation essays. It's almost always that issue, but I want you to put it down even if the contract is in writing. Maybe it doesn't even need to be in writing, but I want you to illustrate that the statute of frauds has been met, and definitely make it its own heading. Be on the lookout for other exceptions to formation like unconscionability and fraud, misrepresentation, illegality, and so on and so forth. So there are exceptions that can apply that are also heavily tested in those pure formation type contract fact patterns. Now in scenario one, the formation essay, you're not likely going to have a lot of terms that are changed from that initial agreement. I always call the first agreement like agreement one. But you might have some sub issues like maybe a brief modification attempt of maybe one or more terms, and you'll just, IRAC it and then get out, and then you're going to get into breach or anticipatory repudiation really quickly if that's that issue, and then go into potentially any remedies. So again, it goes applicable law, formation, offer, acceptance, consideration. Offer and acceptance can have multiple sub issues. Consideration, backup promissory estoppel, backup to formation, quasi-contractual or quasi-contract, and then the exceptions to formation. Number one, the statute of frauds. Don't forget that there are exceptions to the statute of frauds, and then going into maybe some sub changes or excuses to performance like impossibility, impracticability, frustration of purpose. But usually those issues are not major issue spotting issues. Wait, that sounded very redundant, but they're not typically tested back to back because they come up more in essay 2, the second type of contracts essay. So really you're dealing mostly with the formation topics, and you could really go from statute of frauds right to breach in the scenario 1 and then right into some remedies. Now I want you to always go into expectancy damages. I want you to always go into reliance damages, and I want you to always talk about consequential damages, regardless if the question is asking for remedies. Those 3 are tested in almost every single contracts essay, regardless if it's 1 to 3 of the scenario. Okay, so that was a mouthful. That's scenario 1, or heavy formation type fact pattern. Scenario 2 is where the facts tell you, usually in the beginning, that the contract is a validly written contract, and that therefore formation you can assume has been met. So the statute of frauds is met and the contract is valid. So you're looking like language, again, looking for language that says the contract has been formed, the contract is written, the contract is valid. If you see any of those words, you are not in a formation essay, meaning you don't have to substantiate formation. Now, I still want you to make a heading, applicable law, apply either the UCC or common law always. You might have the predominant intention test, predominant factor test, if you have what looks like a mixed contract, and that's where you'll discuss it at the beginning. And then you're going to go into formation, but you're just going to substantiate that the contract is valid. You're not going to go into offer acceptance consideration. You're going to quickly just make a paragraph, a transition paragraph that states, pursuant to the facts stating that the contract is valid or is in writing, there is an assumption that the contract is valid, formation has been met, and the statute of frauds has been met, and therefore formation is valid. And I'm being a little redundant right now because I'm not writing, but you get my point. You're validating that the facts are telling you formation has been met, and then you're going to go into the sub issues of potential changes to the terms in that first agreement. So now you're looking to see, okay, there was a dress that was going to be made by an Italian designer. I always give the example in my class, like J-Lo's going to the Grammys. We all know about her famous green print dress. And there's all these terms in the first communication and then the valid agreement that happened. So that maybe it's the type of material the dress is going to be made from. Maybe it's the price of it, the delivery date. So you're going to look for issues in this essay, this second scenario, okay, like modification, like conditions, express conditions that potentially are being modified, a time of the essence provision. I will deliver the dress by January 15th, okay? That needs to be modified if, in fact, let's say the designer cannot deliver the dress by that date. So there's a lot of scenarios that can happen, and you're on the lookout also for parole evidence rule. You're on the lookout for impossibility, impracticability, frustration of purpose, where there's an excuse to non-performance, and you don't need to label the category that you're in. You're literally just listing the issues as they come about in the fact pattern. And really what you're doing here is you're asking yourself, are any of the potential changes or non-performance to the terms in the valid agreement valid? Is there a contractual concept of law that can back up a potential change, or that can also provide an excuse for non-performance of one or more of those terms? And you really only need one. So if it's a valid modification, there might be additional rules, like in common law, there has to be additional consideration. Under the UCC, there has to be a good faith effort for that change. So you have to know the specific rules quite well. Bringing it back to the UCC in these types of questions, which can also come up in UCC formation type essays, you want to be on the lookout for the warranties, okay, the UCC warranties. Make sure, I believe it was, I could be wrong, but I think it was February 2016 where there was a heavy UCC warranty question. Look at that one. It's the one with the surfboard and the epoxy, the material that was used, I believe, to wax the surfboard, and I think it was defective when it arrived. So that's a really good essay, a pure UCC essay you can take a look at. I actually am tempted to look it up on my computer to make sure, but I'll leave it in the comments that it is the right essay. I'm pretty sure it is the February 2016. In any event, you're going to get out of the potential terms being changed. You're going to go into maybe any excuses. Keep in mind frustration of purpose and impossibility and practicability. They all merge together, separate IRACs, but they're usually tested in the same essay. And then be on the lookout here for anticipatory repudiation, one of the most highly missed issues. So what you're looking for, the type of facts you're looking for here, are facts when a party unequivocally communicates that they are not going to perform any of the terms of the agreement. So it's not the totality of the agreement, it's any part of the agreement. I'm going to provide you as a computer software designer 4 programs, but now I tell you a month later, a couple weeks before my delivery date is due, I'm telling you that I'm only going to deliver 2 out of the 4, anticipatory repudiation. So unequivocally not going to perform. You really want to make sure that you analyze that unequivocal standard and also give the remedies to the non-breaching party in your rule statement. That comes up almost every, making sure you have that in your rule statement whenever that is tested. So be on the lookout for tongue-tied, anticipatory repudiation. It will serve as the breach to the contract. So that's something to keep in mind as well. Now, if you don't have that anticipatory repudiation, then be on the lookout for major versus minor breach. Always go into that. And of course, any applicable remedies. Whew, that is an overview. It's not that detailed. There's much more that goes into this lecture, but I'm just giving you a brief overview. If you're not in my course, you don't have access to my contracts approach. We have some of that up on YouTube, but hopefully this is helpful. Okay, third scenario, and feel free to ask any questions in the comments too. Third scenario is a remedies contracts essay. So here is a scenario where you may have specific performance being tested and you're not having to go into the formation of the agreement, although that isn't a term, a valid contract of SP. You are really getting quickly into the remedies and any defenses to those remedies. So that's what you are being tested on, and you'll see calls of question like, what remedies are available? So they're not asking for any monetary damage per se in terms of, well, let me back that up. It's not that they're not asking for monetary damage. They're not asking for the specific breach, because obviously in remedies, there's compensatory and then equitable damages. But they're asking really for what types of remedy is going to be available to the non-breaching party. So you're going into more those remedies as opposed to substantiating the contract or going into any change terms or excuses to non-performance of any terms of the agreement. So you'll be able to see these as you do your remedies practice, but that is the third scenario. And I'll make another video about remedies. It kind of is a video onto itself because there's all these different types of remedies to be on the lookout for. If you want our full approach, you can reach out to us at cabarstyle@yahoo.com, and we'll send you a link where we sell our approaches. They're going to all be available on Amazon. I've been teaching these for 15 years, and they're taught, not taught, but they're purchased all over the country. Applicants use them in law school and, of course, on the California bar and even the UBE, but they really are designed specifically for the California bar exam. They are just helpful if you're learning that topic and you need some help on how to write for it. Okay, I hope that makes sense. And if you have any questions, let me know. With contracts, this is the good news, as it can sound very philosophical in a sense. The more practice you do, you will see such redundancy in the way that these 3 scenarios are tested. So you're going to see so much redundancy in not only the way it's tested, but the flow of the formation. Like you always have all the formation facts on top, and then it kind of goes into maybe some terms, or you might even just have the breach and then the remedy. So really take your time, do a ton of contracts issue spotting, not even writing. I would start by issue spotting at least 4 to 5, 6, and like 2 formation, 2 more terms, scenario 2 breach, and then 3 a remedies question. I hope that helps again, and let me know if you have any questions.